this comment. So they're asking, how do I plan on evidencing that the borrower is no longer obligated on the note from a legal standpoint? And then they're also presenting that court cases don't support it. Material that is presented on my page is always backed and supported by legal statutes, acts, and some real life evidence.
I'm constantly worried that people will misinterpret.
Court cases, you're right. A lot of what is being said here is not going to hold up in court. A lot of what is being said here is not going to hold up in court.
Wait a minute.
A lot of what is being said here is not going to hold up in court.
So now let me explain. We continuously keep stepping into the legal world. We continuously keep wearing a hat that someone placed upon our heads when it's too small. It don't.
You're rocking with the best. Bring that one back from the top. Bring that one back from the top.
Go read this comment. So they're asking, how do I plan on evidencing that the borrower is no longer obligated on the note from a legal standpoint? And then they're also presenting that court cases don't support it. Material that is presented on my page is always backed and supported by legal statutes, acts, and some real life evidence.
I'm constantly worried that people will misinterpret.
Court cases, you're right. A lot of what is being said here is not going to hold up in court. A lot of what is being said here is not going to hold up in court.
Wait a minute.
A lot of what is being said here is not going to hold up in court.
So now let me explain. We continuously keep stepping into the legal world. We continuously keep wearing a hat that someone placed upon our heads when it's too small. It don't fit. We don't like how it looks with our outfit.
Pardon?
It stinks and it's old. We continuously keep worrying about what the neighbors is going to say, i.e. court, right? We keep worrying about whether or not we are saying the right things to the right people in the right moments. I'm not saying that that is, a problem. What I'm saying is that that is why we continue to be enslaved, imprisoned, held back. For years, this nation has made laws and obligations and placed them upon the people who put them in charge, okay? And they've created an entire system that works for them. It was to benefit us, but it also works for them.
Can you get to the point?
And not only does it work for them, but they have been able to maneuver themselves into it like a snake in order to create their own caveat to get us to do their bidding, so to speak.
And bibbity bobbity boo is y. Put them together and what have you got? Bibbity bobbity boo, x plus y equals y, x equals 0.
So when this person talks about legal standpoint, what I'm presenting to you is supported by the law. It is supported by the banking law. It is supported by trust and contract law. It is supported by securitization. It is supported by settlement and clearance. It is supported by the acts created by Congress. So you may not be able to go into court and tell the court that, hey, I know that I ain't supposed to be paying for this note because I'm the creditor and it was already settled through the DTCC.
You serious?
What you can do is force that bank to present that original note and show that they no longer have it, which means they have no right to foreclose. And that is supported in the Uniform Commercial Code. So although what I'm presenting, not teaching, may not be something that you can walk into a bank with, may not be that you can go into a court and win a case with specifically, but as a collective piece of information with the laws to support it, you can now utilize your own knowledge and energy to direct the conversation properly.
What does that even mean?
This is what I keep trying to get you guys to understand when I say make it make sense, okay? So yeah, you're not gonna tell the bank or the court or the fucking whoever that, I'm the creditor and my note was settled. They're not gonna hear that because it don't benefit them.
This is 30 seconds for my man Lamont from the Supreme Elite Team. Man, my mindset before I came over here, I was heavy on that sovereign citizen for a minute, and then I got guided out of it. And you just further reiterated how stupid I was, how much money I lost by following that stupid mindset. I came to you with a problem that I had, even though I was getting some type of proceeds from certain filings. I didn't have the understanding that I needed to really support what I was filing, and I knew that. And then when I came across you on YouTube, man, I said everything you were speaking about was everything I needed. the regulations, the laws and everything that supported the filings that I was doing is everything that I needed. And you became my teacher's teacher. And actually, I don't even mess with that dude anymore. I'm strictly a Supreme Elite team member. 100%. I don't want to say that it's like on that Jim Jones shit, but really, man, your knowledge and insight has really taken me to another level where I ain't really questioning half the shit you give me. Because I know with everything you give and you teach, you give the documentation, the laws, the regulations, everything to support it. And I really appreciate you allowing me to become a part of the Supreme Elite team. I sent a friend of mine over to you, and the amount that you told me it was to join the team, he said it went up. I say, man, it's valuable information. You can't even look at the dollar sign for real. But hopefully he'll be able to become a part of this team, because he ain't going to be getting the information from me. He got to get the information from the source. That means it's you. And man, a lot of the stuff you have given me has changed in my life and my family. I know you say don't think about the proceeds. I'm in the process of waiting for some proceeds. Because, sometimes a lot of people want to see that knowledge and information put to work. And I'm one of them dudes. I already know that everything you gave me is factual. The regulations support it. And I'm just waiting for the proceeds. So when I get my proceeds, you'll have some additional proceeds. But man, I can just say that I've done a complete 360. I'm sorry, I've done a 180, because 360 means I'm back where I started from. 180, I'm going in the proper direction. I was being led away from the information that I needed, and you have turned me around, made me do a 180 to go back in the opposite direction, to point me in the proper direction. We did it right. We did it right.
Credit acceptance was trying to finesse me, high interest payments. No, I couldn't let them get me caught in front of the house inside Mercedes Benz GLE. Was something wasn't right, I had to do it right. Yeah. Sent the email with the proof, then I filed a suit. Yeah, judge saw the evidence, then they called the truth. Just like that, gone. They settled quick, title on the way, and the debt was wiped away, and I ain't even had to pay. No, push the whip with a drip. You know I got the stick. You know I say the case. You know that they legit. Hey, proceed be the way. If you know how to play, get the win, drop order, then you get on out of the way. 50K right away. Thomas did it right. Now these haters gotta say that Thomas did it right. Go real talk about what to do, but Thomas did it right. No guessing about the law, cause Thomas did it right. Interest rates high, but Thomas.
Welcome to the new culture empire. You are now live with Thomas, your teacher's teacher and the blueprint.
Wait up, run it up. I'm in the kitchen, cooking up something new, yeah. She's singing along to our favorite tune, wow. Enjoying the breeze from Toronto, they admire my watch at the show. You seem like you had something to share. What's up? I thought so. Okay. I'm back in this game, now you're waiting on the bench. I thought so. Okay. He's back in this place like he had left something behind. Celebration for tonight, I'm feeling ready for the night. Confidence high, we making moments to remember, and leaving behind the worries, moving forward clever. Got a plan but no rush, just taking it slower and better. Embracing the job with Brandon and Joy, and right. My confidence never wavers when I'm focused on the table. No time for negativity, let's lift up. This energy's electric, bringing us together. Feeling alive and fulfilled. Shawty saying that I am the one. Who does she think she's talking to? She wants someone who brings unity. After freshening up with a clean routine, the momentum's back, Greek inspired and free.
You're rocking with the best. You're rocking with the best.
New Culture Empire, we are back in the building with another banger for you today. Reporting live from the New Culture Empire Studios in association with the Supreme Elite team. And of course, you got to shout out the Accrual Accounting Collection Agency, because without that, we wouldn't be able to find what's really going on. Shout out to all the Supreme Elite team members. Shout out to every single one of you. It's been rocking with me since day one. Shout out to the one. Shout out to the one on your success, on the success of the claims of your merits. It's always a good feeling when others in your group catches the gems, breaks it down, understands it, and then use the same information and the knowledge and the understanding to help your loved ones, like you did with your wife today. So that was a major one. Because it's always easy to write it off. It's always easy to write it off as, hold on, let me make sure. Damn, I forgot to let TikTok know. It's always easy to write this stuff off as, oh, well, the teacher always shows up with the wins. The teacher always shows up. But when your group members are also getting victories in their own right, it's more gratifying for me more than it is to them, because it goes down the line. I have people who are way more advanced, who already been there, done that. And when I was a newbie learning from them, they've already achieved a lot of success in this financial world. So we're passing it down. We're passing it down. Now, one of the things that I want to talk about before we get into the securitization and why these things fail, I've noticed an uptick in a trend. And YouTube, please put a 1 in the chat if you can hear me. Please put a 1 in the chat. Y'all share the screen at the stream, because we're still on the shadow ban ain't what it used to be, but people are still saying they're not getting notifications. So I try to post the notifications all over, or they get the notifications late. YouTube is kind of late on sending out these notifications. But shout out to TikTok. TikTok streaming live from YouTube and on TikTok at the same time. Now, if you can hear me, YouTube, okay, loud and clear, perfect. All right, so once again, I keep saying the same things over and over, which may seem like it's a broken record, but I feel like it's necessary. One of the things that we have to understand, that I hope people understand and my group members continue to understand, is that the way the financial system is designed and set up, there is no room for any type of theories, methodologies, that doesn't align with the normal standard operating procedures and what they operate in every day. And I'm fighting the cold, y'all. So if I sound like my nose is plugged, that's what it is. I don't care if it's an administrative process. I don't care if you're sending documents directly to the company. I don't care what you're doing. I don't care what it is. If you cannot prove to them from a legal standpoint any documents that you send in that there is a significant chance that you will win in court, they are not going to take your claims serious at all. Now, the myth is I send this document in and everything just wipes away. If for anybody that teaches or that's part of their whatever they teach, I want y'all and I need y'all to start asking the question, how is this one document going to evidence or cause or trigger my account to reflect 0 from a legal and an accounting standpoint? Now, with the new culture empire, they won't be able to give us any answers because we know those answers from both levels. But if you hear any talk that says something along the lines of, I'm the creditor anyway, anytime you hear someone talks about whether it's a mortgage borrower, an auto borrower, credit card borrower, anytime you hear someone says, we are the creditors anyway, you run as far away from them as you can. Because from a legal standpoint, remember the contract lens, you are the borrower on the contract. The courts are not going to recognize any claim saying that you are the creditor. So I find it interesting is because what I notice in these spaces is there's always this vague, produce the note, I'm the creditor anyway, and then that's it, without any breakdown from a legal standpoint or how you can evidence that in a court of law. Another thing that I've noticed is that anytime that you have someone giving advice, information, and everything that they're saying, they can't then turn around and say, okay, so if I was to bring my claims in court, this is what most likely the judges have already ruled on claims of this kind. Anytime you hear people say that, oh, step away from court. Oh, you don't worry about court. Oh, you don't have to put a hat on. They want you to go to court. They're only saying it because they don't know how to evidence it in a legal court. They always want to disavow and persuade you to stay away from court when they know none of their claims will be recognized in court. Because the legal standard is the measurement of any claims or anything that you're teaching online. And this is why when it comes to these online spaces, they can talk for hours about what methods to do, how to go about it. They can explain to you for hours. But when those same people has to put it on paper and go to court, it's very vague. No substance. And this is what I call misinformation. They're not living in the reality of the real world. If you can't prove you can win in court, you have no claim. 1 second. That's just what it is. If you can't win in court, you have no claim. So let me add this back to the stage.
So they're asking, how do I plan on evidencing that the borrower is no longer obligated on the note from a legal standpoint? And then they're also presenting that court cases don't support it. Material that is presented on my page is always backed and supported by legal statutes, acts, and some real life evidence.
Okay, so I'm gonna break this down. It's supported by legal statutes, right? And evidence. Okay. Where is the venue that you go to bring a claim under a statute? You go into court. Who interprets how statutes are written? The courts. Who has the final say on the interpretation of statutes and regulations? The Supreme Court. So by her own words, if it's supported by statute and you're bringing a claim, which you must have a legal cause of action, and you're bringing a claim under statute, what does that mean? You have to go to court to have the statute enforced. That's what it means. There's no way around it. Let's continue.
I'm constantly worried that people will misinterpret.
Court cases, you're right. A lot of what is being said here is not going to hold up in court.
Right there. Court cases, you're right. A lot of what's being said here is not going to hold up in court. Effilade, you just killed everything else that you're about to say. Because if you can't find evidence of prior rulings and matters of this kind in court, you have no claim. The real issue is what they're telling you online has consistently been rejected by the courts. And this is why they tell you to stay away from the courts. It's because they can't win in court with these arguments, but they will still want you to go buy their packages, take their courses, to end where? At a dead-end street. Because she said it out of her own mouth.
A lot of what is being said here is not going to hold up in court.
Wait a minute.
A lot of what is being said here is not going to hold up in court.
So I have another group member who just achieved another win based on the blueprints that's taught in my group for his wife. I wonder if he actually went to court to get that done. I'm being facetious, y'all. He won in court. So anybody, once again, that's saying, oh, there's no accounting that you can raise in court, there's no laws on accounting, they're lying to you. The real answer is they just don't know they exist. It's because they're looking at it from a consumer standpoint, and they're looking at accounting and securitization as a legal defense, as basically saying, because of this accounting and because of securitization, I don't owe the debt anymore. Because they made some money on the side with securitization, I don't owe the debt anymore. There is no quicker way to get your case thrown out than to say, because of securitization, I don't owe the debt anymore. The problem, and which makes me a problem to these spaces, that is the number one thing that they push to people as part of their defense, whether it's a foreclosure, auto, whatever, in court, is that because securitization took place, it alters the underlying obligation to pay. It doesn't change the underlying obligation. And this is something that the courts have said repeatedly. They've been telling you through their opinions. I went over court cases live on this channel, post documents about it. But guess what? The mindset is, if the courts even rule different from what I believe and what I've sold people on, then we're going to ignore the courts and continue to go. Because with the new culture empire, just as the one got his victory today, we are concerned about getting the job done. They're concerned about being right and saving face. There's a difference.
So now let me explain. We continuously keep stepping into the legal world. We continuously keep wearing a hat that someone placed upon our heads when it's too small. It don't fit. We don't like how it looks with our outfit.
That's another way of saying stay away from courts, because none of what I talk about can actually hold up in court. This is where the gaslighting comes in at. This is where the disingenuous part comes at. Now, why do we got to go to court? Because they say go to court. Ma'am, the rules have been set in stone for hundreds of years. Just because you misinterpret what you read, or just because you've grown emotionally attached to a certain particular process that you're doing, doesn't mean that the courts are any invalid. Anytime you hear people disavowing the courts, don't go into court, it's because they can't win in court, because they're not good enough to win in court. That's the only reason why they tell you to stay away from court. And what do you end up doing? You ride the administrative process trail for the next 10 years, spending thousands of dollars in certified mail receipts, sending things to the CFO, which they're never going to read, because the CFO does not accept unsolicited mail, and they don't accept communications from borrowers. They'll send it to the indentured trustee. The indentured trustee has no loyalty to anyone but the investors. Is written in their contracts and agreements. This is why they never respond. So you're going to continue to keep sending documents and documents and documents and documents, and you're not going to get anywhere. And when they do respond, they're going to tell you it's frivolous. Now that you're severely behind on your debt, now you got to go in overdrive, thinking this one document is going to make everything go away. I don't live in La La Land. I live in the real world, just like all of you. There is no administrative process that's going to get you out of a $500,000 mortgage debt. There is no tax filing that's going to get you out of the contract. There is no trust process that's going to just say, all right, you can keep the house and you don't got to pay for it no more. Because many people come to these spaces as another form of debt relief. See, that's why they come to the spaces anyway. See, what makes the New Culture Empire so different from everybody else, that we don't treat this as a debt relief. We come to these spaces and then we go to court to assert our claims from the jump. See, we don't once again, we don't do what everybody else does. This is why you can scroll on this app, you can scroll on TikTok, you scroll on Facebook, you scroll on any one of these social media platforms, and you're going to have all the teachers and some variations doing the same sovereign citizen rhetoric in whatever remix variation that they're doing today. It may not look identical to the claims from 25, 30 years ago, but it's some variation, just like in her response. And you notice they always do video responses to my questions. They do video responses to my questions because my questions always hits a nerve. Can everything that you're talking about, can you prove that you can win in court? It's a simple question. And if the answer is yes, okay. If the answer is no, stop listening to them, because you'll be wasting your time.
Pardon?
It stinks and it's old. We continuously keep worrying about what the neighbors is going to say, i.e. court, right? We keep worrying about whether or not we are saying the right things to the.
But once again, you have to worry about what the court's going to say. You have to worry about if you're saying the right things. See, this is another variation of that sovereign citizen. I can just do whatever I want, file what I want. I'm not under your rules. I don't have to follow the court rules, and I still expect to win. Because many people, whether right or wrong or indifferent, whether they're filing legitimate claims or filing sovereign citizen documents, they're still going into court. And this is the difference why we respond with motions and pleadings, while they respond with affidavits and notices. There's nothing in the court rules that tells you to respond with an affidavit or notice. And we have fallen so far from grace that many people don't even know the basics of how this stuff works. They went so far off the track from day one that it's going to take them a leap year to just get back to the normal, regular basics of court. Like the normal, regular, not hard to understand basics. It's like a mathematic chemical equation to many people because they approach this stuff from a belief standpoint. It's always about what I believe is true. Whether does the facts, does the source, does all the evidence point to whether I'm right and wrong? See, once you start to believe that the process that you're doing is true, instead of just following the facts and letting that lead you where it takes you, you will become biased in your assessment. You'll start to interpret a statute in a manner that has no relation to what you're reading. You'll take a word which has its normal everyday meaning, and then you will purposely apply the 1800s Black's Law Dictionary. You notice how every time the courts quote or cite a definition from the Black's Law Dictionary, they're always citing the latest edition. You notice that? Because the latest Black's Law Dictionary are the times that we're in today. But many people would say, oh, they're taking the words out because they don't want us to know. See, it's always some form of a conspiracy theory, and these conspiracy theories always come into play when people cannot figure out why their claims are not being accepted. And it's not so much that they can't figure it out. They refuse to accept the writings on the wall. So that's that. Remember, it's always an excuse why they lose. It's always an excuse. Their documents could be dead on arrival. Their court filings, they could literally be filing an identical claim in which the courts have rejected for the last 25 years. But these same people will still say they're not wrong.
Right people in the right moments. I'm not saying that that is, a problem. What I'm saying is that is why we continue to be enslaved, imprisoned, held back for years.
Okay, so just because the law says if you have a civil dispute, you go to court. So that's us being enslaved. But Efilade, the last time I checked your channel, I haven't seen a title that you won based off what you teach. Last time I checked, I haven't seen an account wipe to zero based off what you teach. Last time I checked, I haven't seen a title to an asset that you own outright based off what you teach. See, that's where we get all the fluff out the way and we get straight to the reality of it. Because your method means don't go to court because you're not going to win, but what we're talking about is still right. My method is we learn the rules to the game. We have set you available. You learn the 5 lenses of the contract. You understand the game fully first, and then you step in court and win. And you don't need to worry about, well, is this going to work? Because I paved the way, I led the way, I became the blueprint, and I led the charge first.
You're rocking with the best.
I led by example. So you don't have to worry about, oh, it's a theory, or I'm just taking a shot in the dark. I led by example. And not just me. Another one of my group members got a victory today for his wife based off the Supreme Elite team. And not just today with him, his family member, who's not even in my group, got a victory off what I teach. So it ain't just about me. This is changing the mindsets of people and their families for years to come. What I'm doing with the New Culture Empire and the Supreme Elite team, we are revolutionizing the way consumers litigate their claims. We're revolutionizing it. And you ain't got to, I'm not, trust me, I have no reason to sit here and lie to you. Because it makes me no difference. I'm still going to know it. I'm still going to understand it. Can't nobody take it away from me. I'm still going to be able to move effectively through this financing world with no hiccup. The question is, are you getting the actual results that you're really looking for? Do you fully understand the system from a corporate finance, from an advanced accounting, from an investor regulator standpoint? Do you understand the 5 lenses of the contract? Can you look at one contract and explain it 5 different ways, or what it means in 5 different areas? From the consumer standpoint, from the court standpoint, from the regulatory standpoint, from the corporate finance standpoint, and from the investor standpoint. Can you do that? See, that's a question that you have to ask. You don't have to worry about me. See, it's not about me being right anymore. It's that we're past that ship. That ship has sailed. My settlement, that ended all doubt. That ended all doubt. So it's not about trying to prove if I'm wrong or right. Now it flips. Now everybody else, you got to prove what you believe and what you teach and what you advocate for. You got to prove you're right. I already proved I was right. But the reality is, if what you're teaching and advocating is not on par and what I do, then by default of me being right, that means you're automatically wrong. And that's the pill that many people don't want to swallow.
Years, this nation has made laws and obligations and placed them upon the people who put them in charge, okay? And they've created an entire system that works for them. It was to benefit us, but it also works for them.
Can you get to the point?
And not only does it work for them, but they have been able to maneuver themselves into it like a snake in order to create their own caveat to get us to do their bidding, so to speak.
This is that horror story. Oh, they've tricked us. They got us enslaved. What? I don't feel enslaved. I didn't have no problem with court. Why is it that our realities and me and the one's reality is a totally different reality from hers? Why is it that I can say everything that I'm talking about, I can show you that we can win in court? As a matter of fact, the top tier professionals who sits on the American Accounting Association is agreeing with me. A top accountant that spoke at the SEC conference agrees with me. An ex-SEC attorney agrees with me. A 25-year CPA in the game agrees with me. An ex-Federal Reserve bank examiner agrees with me. Credit acceptances attorney agrees with me. And actual judges who's put out their own literature agrees with me. And everything I'm saying, you'll see it. See, we don't have this horror story, this doomy gloom mindset of the system, because we don't try to take our belief systems and impose it onto the system. We learn from the top professionals in the world. The one, based on your own results, everything that you've utilized from what I teach, based on everything, can you say yes or no that I kind of know what I'm talking about based on your own results?
And bibbity bobbity boo is why.
Supported by settlement and clearance to get us to do their bidding, so to speak.
And bibbity bobbity boo is why. Put them together and what have you got? Bibbity bobbity boo, x plus y equals y, x equals 0.
So when this person talks about legal standpoint, what I'm presenting to you is
legal, yeah, she's talking about me. A legal standpoint. And this is why damn near all of these social media content gurus, especially on TikTok, they have nothing for me. I ask one question and all of them get their panties in a bunch. You want to know why? Because they don't even realize the origins of what they teach. See, everything that she said, and she responded to this comment, I actually broke down the origins on what she's saying. This is why she's going to say the clearinghouse. This is why she's going to say the DTC. The DTC has nothing to do with consumer transactions. You know what that came from? That came from the redemption movement, the patriot movement. See, many people think that what they're just finding out today is so new and groundbreaking. But what they don't realize is, what are the origins of what I'm teaching? Because they think they just discovered it today like it's new. Ma'am, everything that you teach, I swear to God, it's been the same regurgitation for at least the last 30 years. A lot of what you talk about, they was trying to find process to do about this stuff in the 90s. In the 90s.
It's supported by the law. It is supported by the banking law. It is supported by trust and contract law. It is supported by securitization. It is supported by settlement and clearance. It is supported by the acts created by Congress. So you may not be able to go into court and tell the court that, hey, I know that I ain't supposed to be paying for this. No, because I'm the creditor and it was already settled through the DTC.
There she go. What did she say? I know I'm not supposed to be paying for this. No, because I'm the creditor and it was settled through the DTC. You notice how I said that's what they're going to say? I know what they're going to, I know everything that these people teach. Everything that they're talking about, I already know what they're talking about. And I still tell them none of that's going to work, because before you were saying it, everybody was saying it 30 years ago. But you want to know one thing that they're not going to do? They're never going to learn the system from a corporate professional, because they've been fed these horror stories about these corporate professionals and these bar attorneys. See, they'll never take the advice of an ex-SEC attorney like I did, because these attorneys are bar card registered. They work for the British Crown. Stay away from them. You are operating in the corporate finance world, whether you realize it or not. There is no secret, separate world for those who just so happen to wake up and figure it out. Whatever you believe in, you are operating in the same corporate financing structure. If you don't know the game from their level, from a corporate finance level, from a regulatory level, from an investor level, from a highly advanced accounting level, from a securities law level, and then tie that into court with supporting your actual legal cause of action, you have nothing coming to you. So you have a comment here. He said, the first attorney walked out of court and told my cousin, please don't tell the head attorney of the firm he lost to a consumer.
You're rocking with the best.
I told you, I am revolutionizing how consumer litigation is argued. Now, is that to say that every case on the trial level is going to end in a victory? No. There's going to be times where you have to go on appeal. As a matter of fact, all the rulings that were favorable to the borrowers, at least for the past 30 years, from what I researched, everybody had to go on appeal. Lower courts rulings are getting overturned all the time. But regardless of the outcome at the trial level, our claims are right for appellate review. And you have to understand that court is not something you can just read a book or read a packet on. Court is mastered through experience. Let me say it again. Court is mastered through experience. It can't just be your first time ever in court without thoroughly researching the court rules, the regulations. The court rules and procedure, rules of evidence, and think you're going to walk away winning. Because you know what the other opposing attorney is going to do? They're going to mop the floor with you on the rules of procedure. They're going to, you notice how whenever they get a motion to dismiss granted, you notice how they never really get into the facts of your case. they all scalp you from the roof off rules and procedures, because many people think court is about they did this to me, now I should win. And they neglect the rules of procedure, the timing of the motions, the procedural posture of the case. Hey, what was the status of my account? Am I current? Did I bring the action first? You know, that represents less than 1% of people in these spaces. The other 99.99% are in default and the defendant. That makes your procedural posture a little weaker. Now you have to do a lot more maneuvering. And this space, they believe it's a come if you're in debt. Well, why am I the only one in the new culture empire? Are we the only ones talking about bringing claims while you're the current and you're the plaintiff? Why did these gurus tell you to stop paying when you come to them? You want to know why they tell you to stop paying? Because they have no process for you if you were continue to pay while you're getting your litigation together. See, they tell you to stop paying. I tell people continue to pay while we get this lawsuit prepared and drafted. See, there is a difference there. Whether you want to admit it, recognize it, or not, there is a difference.
No longer have it, which means they have no.
So remove that for a second. Now, there has been people who's been trying to copy the blueprint. There's been people, because you know these spaces is like ants at a picnic. You drop a piece of hot dog on the ground or burger on the ground, then you look down back at the ground, it's like 5,000 ants on it, picking it apart. That's people in these spaces. And the reason why it's them, because many people don't want to use their brain and they lack the patience it takes to fully understand the system. All people had to tell them is do this and get this out. Many people lack the patience. They don't have the patience nor the mindset for this. And we act like those things are not synonymous with this, the angle that I advocate for. So why would a person have to learn and take the time? Because remember, they're impatient. They expect things to happen fast. You know, you could be ignorant for 30 years of what's going on. As soon as the light bulb goes off, you expect to have it all back in 45 days. I wish that was true. But what people are doing, they're trying to copy the blueprint. And what they don't understand is by trying to copy the blueprint, they're only weakening their position, because court is not about copy and pasting what someone else did. Court is going to rest on the facts and circumstances of each case. So if you think you're just a copy and paste person, think you skip the line and it's going to work out in your favor, you're going to be in for a rude awakening. So let me be direct about something that I know a lot of people don't want to hear. Most online content about securitization, I'll just explain this. It's not wrong because it just solely mentions securitization. The reason why it fails, because it misuses it when you're in a legal setting. There is a big difference between understanding how a financial system works and winning a case inside a courtroom. You notice how they could all tell you what's going on? Oh, you're doing this, and they do this, and they do this. Look, they do this. Look, it goes here. But when it gets down to putting it in a legal claim, it gets scarce, it gets vague. They don't have the same stamina as they would do if they was on a live stream. Please like and share. Please like and share. Tap that screen. Tap that hearts on TikTok, y'all. Please like and share the stream. And that's where the line gets blurred. The first mistake that people make when it comes to securitization is they treat securitization like a legal defense. I know that I'm ripping the heart out of the beliefs around securitization. To be honest with you, unless whatever process that they're doing, unless they tie it into you don't have to pay anymore, right? Right? You get what I'm saying? Unless it's tied to you don't got to pay. The debt's over. Many people are not going to have any interest in it. Many people would not have interest in securitization if they actually knew how deep the layers go. If they actually knew how many different things you got to know at the same time with securitization, many people will bypass it. But since securitization is now tied to, oh, I don't got to pay anymore, many people have interest in it. Now, what you will hear online is your loan was securitized, so the debt is gone. And anybody that says that's not true, they're going to be stifled. The court rejects that argument consistently. Why? Because securitization by itself does not eliminate a borrower's obligation. See, that is what they don't want to hear, because every process they're doing and they're psychologically connecting it to, I don't have to pay anymore. Securitization does not eliminate the borrower's obligation. That's been addressed over and over in foreclosure and collection cases. Now, let's put the legal lens on for a second. Let's put the legal lens on. The question is going to be very simple for the court standpoint. Now we're in the legal side of the legal lens of the contract. Does a note exist? The answer to it, yes. You know it does. It's the same note that you signed at closing. It's the same note that evidences your obligation to pay. It's the same note that you was making payments on before you became woke. That same note. Wherever you sent your first 3 payments in before you became woke and enlightened, it's that same note. So don't ask for the note. Don't ask for the note. You know the note exists. Because if you did it, if the note didn't exist, why did you ever make a payment? Why didn't you sue them right after closing? Another indicator that your note exists, you wouldn't even be in the house without it. So this is where we got to stop playing game goofy and play semantics and ignore parts of the reality that doesn't comport with our belief system. You know how people just act like that part don't exist? No, we're going to bring it to the forefront. Was there a default? We're grown adults. Everybody knows when they're in default. You know you didn't make your payment on the 1st of May. You know you didn't make your payments on the 1st of June. And you know that you sent a Versa check to them in July. This is how it normally goes. And this is from the people I've spoken to. It starts off them making their payments. Then for whatever reason, they go about 2 or 3 months without paying. And then out the blue, they submit a negotiable instrument to pay. You know that's how it goes. Hell, your gurus have done this. Keanu Stone has done this. Y'all know how it goes. They start out paying. For whatever reason, they stop paying. And then out the blue, here comes the instrument. 1 second. For whatever reason. So does a note exist? You know it does. Was there a default? In many cases, yes. Because that's the only reason why they even get excited about trying to defend when they're in default. They're not excited about defending on their mortgage when they're current in the plaintiff. They're not. Does the plaintiff have the right to enforce? See, that is where your legal understanding of the system and securitization and the corporate finance structures, depending on your understanding of that, is going to depend on how you argue whether they have the right to enforce. So that's going to depend. But in many cases, the answer is yes. So then the broad argument about securitization doesn't defeat those three things. Does a note exist? Was there a default? Does the plaintiff have the right to enforce? A general securitization argument does not defeat that. Remember, we're talking the legal lens. We're not talking about what they did. We're talking about how the courts see it. And that's what I'm saying. Many people has a misunderstanding of what court is and what it's about. So when someone walks into court arguing, this was securitized, therefore it's invalid. You know what the judge hears? You know what the judge really hears? This is not a legally recognized defense. And this is why in many cases, they stay right over the securitization arguments. Unless there is an unless there. Unless you are part of the Supreme Elite Team University.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
Please like, share, and support the stream. If you haven't supported the stream before and you are feeling so inclined to do so, Cash App is pinned at the bottom for your convenience. Now, after the judge says to himself, "Nah, just not a legally recognized defense," the case moves forward. The second mistake, many people do this. They argue theory instead of elements. A courtroom is not a classroom, y'all. A courtroom is not a place for you to tell the judge how the system works. Judges don't decide cases based on general financial theories, your little industry criticism, your little beef with the system, or your internet explanations. They don't decide cases on that. Whatever you think they're going to decide the case on, in many people's cases, they're not. They decide cases based on pleadings, evidence, and recognized legal standards. See, this is where many people don't understand any other lens of the contract but the consumer. Hell, everything they do is from a consumer lens. They don't know how to look at any parts of this system outside of consumer lens. This is why many people don't know how to think like a corporate finance company. Many people don't know how to think like their internal CPA who prepares their financial statements. This is why many people outside of the new culture empire would have no clue as what they're reading if I was to throw a balance sheet in their face. They'll have no clue what they're reading. They wouldn't even know what the terms mean. When someone raises arguments that don't directly attack the standing, the amount due, payment application, statutory violations, those arguments outside of that, you know what the courts treat them as? Irrelevant. And this is why y'all will see so many cases where people say, I brought up securitization and still lost. I see y'all in the comments. I brought up securitization, but I still lost. Hey, I brought up securitization, but I still lost. Right? Want to know why you still lose? And it's not because the concept is useless, like securitization, it's just over with. No. It's really because it was not tied to a viable claim, legal defense, or my favorite. Y'all know what my favorite term is? Y'all know what it is? It's the legal cause of action.
You're rocking with the best.
Securitization is not your legal cause of action. Sorry. The third mistake is ignoring how lenders actually prove their case. Remember, they tell you to stay away from the corporate finance sides. They tell you to stay away from the attorneys. They don't tell you to study their attorneys. They don't tell you to, you know what I do? I even research who's arguing against my client. What's their expertise? What college did they go to? See, these are the things that you just can't be taught. You either have it in you or you don't. See, they don't want to be a student of the system. You cannot master anything that you don't understand. Good God Almighty, we cooking with Crystal today. You cannot master anything that you don't fully understand. And very many people, and I mean many, it may not be all, but many people, from what I've seen with my own eyes, they know very little about a system that they think they understand. They know very little about it. Is they're pushing this stuff, promoting this stuff, advocating this stuff to people who doesn't have enough understanding or information or years in the game to actually fact check them. This is why when I come around, a lot of them get uncomfortable because they can't pull the wool over my eyes. Because when I'm looking at what they're saying out their mouths, I'm looking at it from a corporate finance standpoint. I'm looking at it from a regulatory standpoint. I'm looking at it from an investor standpoint. And I'm looking at it from a legal standpoint. When someone gives a course of action to take, the first thing you should be evaluating, will this claim hold up in court? Now, the third mistake is ignoring how lenders actually prove their case, because lenders don't come into court explaining securitization. You notice how lenders never ever talk about securitization? You notice that, right? They never talk about it, even though it's the foundation of their whole operations. You notice that they never talk about it? You know what they come in with? They come in with a note. No, they file the complaint. Attached to the complaint is a note. See a payment history, sometimes a witness affidavit, and a claim balance. That's it. And if your response doesn't directly challenge the accuracy of that balance, the application of payments, the right to enforce, then you're not actually engaging the case. And this is where many people, they start to take court into a whole, like, the lawyer, the lender's lawyer, and the judge, they're on the same page. This is why you see many pro se people going to court talk about things that has nothing to do with court. Like, oh, they violated the remix tax laws. That's why I don't owe the debt. Somebody please make the connection to IRS tax laws, and which is from the legislative branch of government, it's under that sector, to the judicial branch of government, knowing that we have separation of powers. Where does tax law have to fit in with court? Think about it. They'll tell you, oh, remix challenged the late assignment, the void assignment. But ask yourself, what does a tax law have to do with court? And the answer is nothing. Unless you are in tax court. And this is not something that should be alarming to everyone. This is just normal, simple logic. Normal, simple common sense. These are the questions that everybody that sits in these people's lives should be doing. Like right now, many of them are still outside watching. They're not going to click in on the button and watch and be visible. They're watching from the outside. Now, the fourth mistake, and once again, I see it all day, every day, is the overreaching conclusions. The overreaching conclusions. This is actually one of the biggest ones. Jumping from there's securitization to therefore the debt is extinguished. So you go from, you start off securitization, and then you leap all the way to I don't owe anymore because of it. That's the leap right there where your cases just starts to fall apart. Courts require a logical chain, a legal basis, and a provable connection. Without that, the argument looks at best just speculative. And you already know Bell Atlantic versus Twombly, Ashcraft versus Akbal. You already know speculative, threadbare recitals of the legal cause of actions and making legal conclusions will not survive a Rule 12b6 motion or each state's equivalent like a demurrer. Do you know how many cases I have from pro se litigants? And you can tell they've been in these spaces because they use the same words that you hear these gurus using. Do you know how many times they filed a lawsuit and lost? Bringing up securitization, bringing up the modern money mechanics. You know, like they took my note, deposited into an account, and then loaned the money back out to me. Many people still think the banks operate like that today. Many people have not fathomed that you're like 60 years outdated in how the banks operate. Let me give you an indicator why the banks don't operate like that today. Do you want to know if that was still true today? Do you not know that banks would issue their own direct obligations to you? Meaning they will be funding your own loan for their balance sheet. Do I have to strip it down a little more so you can understand? Meaning they loaned you money out their own assets. Do you know that? Do you know that every law regarding the banks loaning their own money or issuing their own circulating notes have been repealed? The mere fact that those have been repealed is evidence that the banks don't operate from a lending standpoint the way the modern money mechanics depict it. And remember, the modern money mechanics, the ABCs of banking, you know, that was written in the 70s. You know, those are old publications. You know, they talk about reserve requirements. See, these gurus don't do updated. They don't update their information. Whatever they got it from, whatever year it was, they still think in 2026 it still works that way. They don't even realize that reserve requirements have been suspended for almost 6 years now, right under their nose, because they're so focused on teaching from packets and passed down regurgitated information instead of going to the actual source, the actual rules, the actual laws. Want to know why they don't go there? Because they know when they go there, it's going to contradict everything that they say, teach, and believe. But they got to save face because they got to keep the money coming in from the people, because that's how they stay afloat. The average guru that's teaching about cars and autos has not even set off or eliminated their own auto loan or settled their own case. But they'll teach, though. They can teach to you, can't save themselves for the sake of Christ, but they sure know how to teach to you, though. So, see, when many people argue securitization cancels the debt, just like when they get a 1099-C, they think they got a 1099-C because their process worked. In many cases, when you get a 1099-C, it means that they've given up on collecting a debt. Now the IRS treats that as income to you. So now you have to report that as other income unless you file an insolvency sheet with the IRS informing them that you were insolvent at the time the cancellation of debt was made. Uh-oh, that flies in the face of their process working. Huh? You notice how they'll show you a 1099-C, but they won't show you the credit report that evidence that their process work, paid as agreed or settled for less. You notice they never show you the actual credit report. So whatever that 1099 sees on, tell them to show the credit report. That'll tell you. Was the account removed? You want to know why they're not going to show you? It's because it's going to say charged off, uncollectible, delinquent, severely behind. It's going to have all those red X's when it comes to the payments. That's what these gurus are not going to show you online. And it's always these young 21, 22, just read a packet from 30 years ago that think they know some shit. It's always them. And you know, with young people, when you're in your 20s, you can't tell them nothing. You can't tell them nothing. Hell, you can really tell people our age something, but you can't really tell them nothing. Whatever they believe, they believe. They 22 years old and they think they know more than you. 1 second. The problem with a lot of these young teachers in their 20s, they lack discernment and they lack wisdom and they lack understanding. And most of all, they lack experience. So they wholeheartedly believe that they're right. And when you're in your 20s, that's when you're at your most stubborn errors in your life. So if anybody's telling you something you really don't want to hear, you're not going to listen. These are why the young people, they get very persistent on the things that they believe in, even though it's leading them nowhere. Come on, you know I ain't lying. You know I ain't lying. See, when they talk about securitization cancels the debt, I just look at it like, is the amount being financed, is the amount being enforced accurate? Is it consistent with how receivables is actually measured and tracked? Were payments applied correctly? Does the plaintiff have the right to enforce the instrument they're suing on? See, those are questions that the courts are going to recognize. Those are questions that fit into motions, discovery, into the rules of evidence. What makes my approach different? Let me tell you what makes my approach different. Because I'm not relying on broad theories, one size fits all arguments. Every case is tailored to its own facts and circumstances. And we damn sure don't do copy and paste defenses. And I'm definitely not walking to court saying the debt doesn't exist. See, what I focus on is consistency, reconciliation, proof of the amount claimed, alignment between what's alleged and what can actually be supported. See, that is when you get into, that's when you get into the professional way of doing things. See, that's when you get into set you.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. War stories in the fine lines.
See, that's when we get there. I'm telling you, a lot of these gurus, they don't even realize how far away they got to go. Prime example. Remember when Kiana Stone had that masterclass in December of last year? And I got people that still circle around over there. Not one person that's came back saying that they received remedy or got their auto set off based on that $33 securitization masterclass. Not one person yet. Not one person yet. Not a damn person yet. Because that's what they do. They sell you a template, they sell you a process, they sell you a course, and then they tell you to do your research. Well, I thought the teacher was supposed to have all the research done. Checking for its accuracy, its proper interpretation. All they got to do is teach it and explain it to you. I thought that's what you're paying for, their research. No, they're not doing research. And one of the biggest, scariest things about these social media spaces is that the misinterpretation of what the teacher's reading is running rampant. Hell, it's to the point where it doesn't matter if they got it pulling up a statute. The odds of them misinterpret what they're reading or not getting the full context is extremely high. So even if they're pulling up a statute, they still may not be interpreting it correctly. And that's one of the biggest things that when you're being a teacher, you have to guard from misinterpretations, because one misinterpretation can spoil the whole bunch. Believe it or not, many people are going to rely on the misinterpretations of the teacher, or they're going to rely on the interpretations of the teacher. They're going to rely on the interpretations of the teacher. I'm telling you. So there's no theatrics, no magical arguments, just forcing the other side to prove their numbers, their rights, and their claims accurately. Because I think that if you want to win in court, I don't think you need a big, broad conspiracy theory. The better question is the number they're enforcing the same number they can actually prove? That's where the cases are decided. Now, we will be finishing up the final legs of the tax class. Hopefully we get through that tonight. I have a church obligation. I sometimes I hate when I make promises because I be forgetting sometimes. Nah, for real. Sometimes I really be forgetting. So let me see if I can get that rescheduled. I hope I can. I really do. Because I really want to get this tax over with, because we getting back to set you. We're getting back to set you this week. That's what we're getting back to. Okay. That's what we're getting back to this week. So let's go here. So let me pull y'all down for a second. So this is mortgage-backed securities, MBS. Typical standard. You notice that in my drafts, in my printouts like this, these actually comes from professionals. This don't come from no self-created, chart that you see online. Because every chart that I see from these gurus online trying to explain securitization, you notice there's always an entity that's there that has nothing to do with the transaction. They always have one entity there that has nothing to do with the transaction whatsoever. Oh, I got an update, y'all. I got an update. The IRS. I got an update. I'll be posting an update on my community post. I got an update. But anyways, so you have the property buyers, right? Oh yeah, you want to know which bank I'm talking about, or which entity that's there that has no reason being there? The Federal Reserve Bank. Like, they still look at the Federal Reserve Bank as something that it's really not. And if you really, why would the Federal Reserve Bank be involved in everyday securitizations or consumer transactions when they don't issue direct loans to consumers? They only lend to banks. Let me guess, Title 12 USC, 12 USC Section 412. That is one of the biggest misinterpretations ever. You know how old that statute is? Title 12, let's pull it up right quick. One of the biggest, and I think everybody falls into this trap. I ain't even mad at you. Application for notes, collateral required. Let me show you why this is one of the biggest misinterpretations. Because they actually think that your application is what they're talking about here. Remember the literal meanings? Remember, they take the word application, and what do? They impose their bias. Oh, application. Oh, there must be talking about my car or mortgage application. See? That's how they do it. Wherever they need to fill in the blanks, they go right to their belief system and fill in the blanks with their belief systems. instead of the actual proper interpretation. So this is Section 16 of the Federal Reserve Act. But if you look all the way down at the bottom, it's the part that they never do. You see all these different amendments. The last amendment was October 28, 2003. The last amendment was October 28th, 2003. This is the amendment right here. This is right here. Dealing with the payments to the bank provided to the government as depository as official accuracies. It's dealing with the accuracy. The payment. That's it. That's it. Any Federal Reserve Bank may make applications to the local Federal Reserve agent for amounts of the Federal Reserve notes herebefore provided for as it may require. Such application shall be accompanied with the tender to the local Federal Reserve agent of collateral in amount equal to the sum of Federal Reserve notes that's applied for and issued pursuant to such application. Now look how old this statute is, because look at the collateral security they're talking about now. The collateral security thus offered shall be notes, drafts, bills of exchange, or acceptances acquired under Section 92, 342, 348, 349, 352, 361, 372, or 373 of this title, or bills of exchange endorsed by a member bank of any Federal Reserve District, or drawn upon special drawing rights certificates, gold certificates. Look how old this is. Do you know this has nothing to do with them going to get the money for the Federal Reserve for you to get your loan? You know, it has nothing to do with that, right? But your belief systems, that's what they told you in the redemption manual pamphlet. This has nothing to do with it. Does title, oh shit, I could do it like this. Does Title 12 USC 412 have anything to do with consumer lending today? Strictly speaking, Title 12 USC Section 412 has almost nothing to do with consumer lending as you would experience it as a borrower today. It is a technical banking law that governs how Federal Reserve banks obtain physical Federal Reserve notes, cash. And the source is right here. The source is right here. They got the sources right here. See? Comptroller of the currency. Huh? Right there. This section requires that when a Federal Reserve Bank wants to issue currency, it must provide collateral to a Federal Reserve. Must provide collateral to a Federal Reserve agent. This collateral can include notes, drafts, bills of exchange, etc., or other assets Federal Reserve banks are authorized to hold. While it might come up in searches, you might see this cited in legal adjacent, or where do you know where you might see it cited at? Yes. Hold on. Y'all don't see it still. Oh, let me move. I'm sorry, y'all. Let me move this off the screen right quick. There we go. You might see this cited where in legal adjacent or sovereign citizen theories that claim private debts are invalid because they are backed by Federal Reserve notes, which these theories often misinterpret as being uncollateralized or not real money. However, in actual legal practice, has no impact on consumer loans. It does not dictate interest rates, disclosure requirements, or the validity of your mortgage, car loan, or credit card. Institutional only. It is an internal rule for the Federal Reserve System to ensure currency in circulation is backed by assets on the Fed's balance sheet. And here's another source. See, there you go. So when you hear Title 12 USC Section 412, you best believe, and you hear someone like still today breaking it down, best believe you're in a sovereign citizen space. I told y'all it costs nothing to dissect and decipher what these people believe in. It's so easy to just chop them down in half. Want to know why? Because I've already researched the origins of their belief system. They don't even know the origins of their belief system. They don't know. So you have the property buyers, right? You got your mortgage loans, the banks. The bank sells the mortgages to institutional investors. They bundle the mortgage to form mortgage-backed securities and sell them to investors. That is the typical understanding of how securitization and mortgage lending actually operates. Another big, another issue that a lot of people have is they actually believe that they funded their own loan. They actually believe they funded their own loan. No. They truly believe that. No, this pseudo legal way of the system. See, their beliefs that they funded their own loan. See, that doesn't comport with economic reality of how the system operates every day. So now they're taking a belief system to these corporate finance companies. Then they're wondering why they're not getting the outcomes they're looking for. So residential mortgage-backed securities, financial institutions package subprime, Alt A, and other mortgages into securities. As long as the housing market continues to boom, these securities will perform. So now we're getting into the investor lens of the contract, the performance of it. So all the investors care about. The regulatory, you know what? I can't give y'all too much. If you really want to learn and understand, you would join Set U. That's what you'll do. But when the economy faltered and the mortgages defaulted, lower rated tranches were left worthless. So now they got tranches. You got Class A tranches, Class B, Class C, Class D, Class E, Class F. And it goes in order. Class A, the first to get paid, the last to take a loss. Class B, second to get paid, second to take a loss. The ones with the tranches that are probably like B and C, you take on more risk, but there's more interest that you obtain. And this is why your interest rates are so jacked through the goddamn roof. It's not the principal balance that does you in. It's the interest rate that does you in. So many people, they feel like they don't have a way out or they got to take drastic measures. But the reality is they just don't understand how the corporate financing system works. That's the difference between the haves and the have-nots. Understand it. It's not which document you get. It's not whether you got a medallion stamp on the back of your bond paper. None of that matters to them. It has no applicability in their world. So you got the originates, you got the pool, then you got the trenches. Residential mortgage-backed securities are sold to investors, giving them the right to the principal and interest from the mortgages. See, remember when people say that I funded my own mortgage and loan? I put the money up for my own mortgage. I want y'all to ask yourself two questions. Then why aren't you receiving dividends every month as the registered beneficiary? Why aren't you receiving an electronic deposit every month? Huh? And why were you paying on something that you already funded? Oh, let me guess. I didn't know I funded till I was in default. Oh, I didn't know. I didn't know this was happening until I can no longer afford my mortgage. Well, when you were current, why did you? What was wrong then? You know, ask yourself this question. I'm gonna ask you again. What was so wrong with the contract when you were making your initial payments? Can anybody answer that? I haven't got a legit answer yet. Oh, yeah, bro. Freed, I'm always on this side. I'm more principally on this side, broski. I'm principally on this side, bro. Ask yourself this question. TikTok, I'm over here at the New Culture Empire, live on the New Culture Empire. A few more minutes, head to this side. I swear to God, you ain't missing nothing else on this app. You ain't missing nothing else. I swear to God, you not. For many people. Now, most people, some people got some good information. But a lot of information, good information that people got, they're not in my sector. Like a lot of people that got good information on criminal law, that's just not my sector anymore. So I don't really, whatever. So what was so wrong with the contract when you were current? Because you got to ask yourself that question. If there was fraud in the contract, what was so wrong with the contract? Oh no. What was so wrong with the contract while you were current? Let's pull up the next one. I just want to know. I haven't gotten a straight answer yet. And it's okay to give the answer. Just say, hey, I didn't know what the hell was going on. Hey, I was in default. I had to do something. So you got the originator. You got the lender, servicer, originator, credit extended. Right? Then the pools of loans, leases, or receivables, bam. Goes there, right? That's the lender in the borrower side. And then the interest and principals are funneled through class A, B, C, sometimes D, E, F mortgages, mortgage-backed securities, or asset-backed securities. Now, remember, it's not just your mortgage. It's not just your auto. It's not just your credit card. You're in a pool of 20 to sometimes 50,000 other borrowers. So every piece of your monthly payment is being sliced. $300 of your principal interest may be going here. $250 may be going there. About $300 may be going there. About $150 may be going directly to your principal. And this is the reason why you could be paying on your auto or your mortgage for 2 years straight, but your principal balance rarely ever dips. Your total balance rarely dips because all the money that they call principal and interest, all your principal and interest payments that you're making are never really true principal and interest. So what we do is we go and dissect where every payment is going. And any payment that's not true principal and interest, we have a problem. You ever notice why your finance charge, Tila says you can they got to display it or disclose it, but they never really tell you what it actually consists of? We see. You notice how they can never tell you what it consists of? What really consists of your finance charge? And every corporation, every company's is different. Depending on what company and what structure you have, your finance charge is going to consist of different things. But what really consists of your finance charge? I'm based on TILA, based on your consumer contract from the consumer lens. Look on your TILA disclosures. What does your finance charge actually consist of? Itemized, breaking down, because TILA is a sham. TILA is another scam. Yeah. TILA is another scam. And this is why it's never good to just have a consumer-like mindset approaching this. TILA is a scam. Your finance charge, what you're really paying back, is never disclosed on TILA.
You're rocking with the best.
It's never disclosed on TILA. Actually, what you're paying back in interest, 98% of it has nothing to do with the cost of credit. It has nothing to do with it. You want to, only reason why you even got the loan anyway, if you guarantee, just like everybody else in the pool, to cover the corporate debt. That's why they used to call us consumers of corporate debt. Then they call us consumers of debt. And now they just say consumers. So when you think consumer laws, why do you think consumer laws only deals with behaviors of the debt collector? But you're still in the position of consuming the corporate debt. And so look at this right here. So you look at the principal and interest. See, all the principal and interest is going to the asset-backed securities investors. But when you get to the legal side, the legal court contract, they're going to take your ass in court and sue you for the whole principal balance amount, in which they don't even have an unrestricted right to claim. See, these are things that we will prove in court. We prove these things in court. So ask yourself, if it says you got to pay $500,000 back on your mortgage, can you substantiate every dollar of the amounts that I owe? I know you can't. But can you? I know you can't do it. I know what it says on the contract, that's not what I really owe. I know it doesn't. Matter of fact, let me prove it to you. See, when we do which I call it debt validation letters, QWR letters, we're not asking them for the wet ink signature. Hold on. Let me do it the right way. See, we're not asking for the wet ink signature. We're not asking them to prove it was me. We're not asking them for the oath of office. We're not asking them for their authority. You know what we're doing when we send those letters out? We're telling them how their internal operations go. Now you have a problem. What do you want to do about it? You can respond. You don't got to respond. You know where we coming next. And many people, their problem is they'll send out that letter, but they're never really going all the way through with it. They're never really pulling the trigger. If you think you're going to get out your goddamn mortgage by sending them a letter, you are tripping. And if your letter is powerful and authoritative, you know what they're going to do? They're going to ignore you. I told you, Supreme Elite Team, we love silence. Ooh, I love it when they get silent. I love it when they send a response saying, yeah, we're not going to address this anymore with you. I love it. I love it. I love it when he gets silent. I love it when they're silent. See, many people in these spaces, they're still looking for the other party, the lenders, to validate them. They're never going to admit that you're right. They are never going to admit that you are right. No admission of guilt. They're never going to say you are right. And I hope you're not looking for their response in your letter to say that you're right. And from you being right, you don't owe anymore. These people, I told you, the IRS is wicked. I'm sorry. The IRS is vicious. These finance companies, this corporate finance system is diabolical. You will be paying back 2, 3, 4, 5, 6, sometimes 10 times the amount of what they even say that you owe. They'll have people stressed out doing all like just BS for a debt that they even say, nah, this is not what you really owe. Yeah, that's a fact. It's an absolute fact. So you get here. So look at it. So you got the assets, the underlying loans, $100 principal value, right? So you got your loan interest. Look at this right here. Look at this. So you got your 3-month loan interest. 3.5%, right? For 3 months. Plus 3.5% is 3.87%. So then you got 3.87% on the principal. That's $3.87. Now you look here. You got the SPV there, and it goes down to these fees. 0.45% of your interest payments going to those fees. Interest paid on collateralized loan obligations debt. So they got the 3-month term plus the 1.75%, come up to 2.12%. Plus on a 90-day principal, that's $1.91. And let me take this down for a second. So you got the liabilities bonds at $90, right? Sugar breach, look at the excess spread. That's the extra they making off every loan. So, and then the other $10 is the equity. So this chart shows that 98% of what they call interest has nothing to do with the interest. And the interest is your finance charge. The finance charge is the biggest scam of consumer lending in the past 100 years. It is the biggest scam. Your finance charge, it's not even a finance. It's only a finance charge from a consumer lends contract. See, on the consumer world, you call it a finance charge. In the corporate finance world, they don't even call it that. It's not that. It's nowhere near finance charge in the corporate world. It has nothing to do with that. I know I should be getting into it more on here, but this is where you either join the Supreme Elite team or join SetU. This is where this comes in at, because I break it, I get into it in grave detail. Let me make sure. Hold on. I think we got it right here. I get into it in grave detail from a professional level. I told you, I know somebody that works for Fannie Mae, Freddie Mac and them, Ginnie Mae. His job is he processes the payments to the investors. Even in a foreclosure. A foreclosure is not because you didn't pay your debt. See, that's the contract. Remember, they use trust law to siphon our property from us. They use accountant to have what's really going on the books from us. And they use contract law to stick us with the debt. You know what happens in a foreclosure? With any amounts that they receive off a fire sale or judgment, they keep that. You think it's going to your principal balance? Absolutely not. They keep that. Hell, with a foreclosure, let me ask you this. How can you be suing someone in a foreclosure when the mere fact that you even filed a foreclosure suit, you have already admitted from an accounting standpoint that even if you were to apply the proceeds to the remaining balance, there wouldn't even be an account there to evidence it. Oh gosh. Oh my God.
You're rocking with the best. You're rocking with the best.
See, these are the little nuances, the little things that are so tricky that many people are just not going to know. Not even going to know what's there. Not even going to know it exists. Don't understand the underlying economics behind the corporate finance system. This is more the reasons why.
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume. With stories in the fine lines.
Yeah. Yep. All right, y'all. That's enough scalpel for today. I got some obligations I got to get to. SetU resumes this week. If you are interested in anything that we have to offer, I will preface to tell you this first. We don't do payment plans right now. SetU, everything has to be on the wood. Hey, I'm at my limit with payment plans. I do that. I try to recycle it and get it started every 90 days. But I'm at my limit. But we deal with everything dealing with corporate finance, consumer finance, whether you have a business loan, personal loan, mortgage, autos, credit cards. I do my own audits. what y'all call them? QWRs, qualified written response. We prepared those. We prepared lawsuits, whistleblowers, anything that is going on with your consumer finance. We can pretty much deal with. There's not a situation that's going to be foreign to me. It's kind of like the same system. Autos, Set You teaches you the 5 lenses of the contract. One thing I will say about Set You, I guarantee you, when you get in Set You, you're going to learn things that are viable to your understanding in your consumer litigation that you don't even know exist. In many parts, you don't even know exist. Set You is a highly advanced teaching setting. It's not the typical online course. It is highly advanced, highly technical, but it's nothing you should run from. It's because that's how the system operates up there. And we have to learn how to start beating these people at their own game instead of trying to impose our limited knowledge and understanding on them. You got to beat them at their own game. With that being said, you all just called me about. Ooh, sorry. That was the wrong one, y'all. That was the wrong one. But yes, all inquiries should be sent to Thomas Legacy 603. Thomas Legacy 603 at gmail.com. As a matter of fact, yeah, let's rock out to this one tonight. Shout out to everybody in the building. Shout out to all y'all. Shout out to Freedom. Loan fees charged to attain credit. Invest time, price differential. You notice when people say the word, they use the wrong version. You notice when people use that word, they use the wrong version. I believe so. Plaintiff failed to prove enforceable rights with admissible evidence. They got to be able to evidence that, because I ain't want to pay my bills no more type shit. Yeah, that's all it is. Hey, OG Top Cat, you was in the building, brother. I appreciate you. If there's fraud then, if there was fraud now, there was fraud then. That's a fact. If there was fraud now, there was fraud then. That's a fact. What else do we have? Most securitization is intermediary deposit between sponsor, originator, and trust. That's how they have to operate. That's how they have to operate. And banks or lenders originate mortgages, pull them together, then security is created and sold to investors on the secondary market. That is the standard operating procedure, and it's happening whether you want it to happen or not, whether you agree with securitization or not. I'm going to say it again. Securitization is a necessary evil. It is a necessary evil. Nobody wants to be running around here paying for all their assets out of pocket. Hell, millionaires don't even do that. Millionaires and billionaires, they still get financing. Oh, yeah. Oh, yeah. Grants from the government, of course, especially if they're creating something that's beneficial to the American public. Oh, yeah, they're not using their own money. The object is not to be debt-free. That's not the object. You want to be in as much debt as you can, as long as you learn how to leverage the debt so you are creating your own rights to receive payment where you're making a profit still while paying back your loan. But one of the things that you got to understand before you get into corporate debt is when you get into corporate debt, there's always supposed to be somebody else paying back your loan. It's never the corporation that took the loan out. So if you got a loan for $500,000 and you got to pay, let's say $750,000 back, that initial loan of $500,000, you need to be creating your own rights to receive payment, where other people are going to be paying your loan back and you're making a profit at the same time. Welcome to the corporate finance game. You all just called me about 10 seconds ago, so I'm just returning the phone call. Well, at 3:41, I received a call from credit acceptance, but I missed the phone call.
Okay, because I'm showing the last time we reached, or that you spoke to someone in our department was on the 10th. You were looking over your contract and application and said you went over to the...
That's probably what the call, yeah, that's probably what the call was, that just whoever just called me from credit acceptance, it's regarding that for the simple information, simple for that reason right there. And this, I believe I've been very trying to work with credit acceptance, and credit acceptance just doesn't want to show don't want to work with me. And the issues that I have, if I was to, take other actions, I know I would prevail because are my main source of my complaint. And all I said was, I just said, you know what? I'm going to ignore, even though I'm going to ignore that there was never any title from the dealership to credit acceptance who has the loan right now. And then I'm going to ignore the mere fact that the credit acceptance has with the dealership, and my retail installment contract is being used to. And all I said was, knock the principal balance down to 10 grand and I will still pay for the truck, because we know that credit acceptance, like this is stuff I can prove all this. Credit acceptance knows where I come from, and they just say, well, whatever, you signed it, granted, but I wasn't expected to pay to you all. I was expected to pay, and credit acceptance in there says that the loan is not, this is on their, they don't even have me down. And so it's like, I'm just providing the money. Okay. So if that's the case, then I say, you know what? Instead of me paying grand for this truck, how about knock it down to about 12,500 or 10 grand? Let's recap it off. Because at the end of the day, credit acceptance, my loan. If I was to go to court and say, hey, they're not, which is required in the state of Virginia to be a lien holder. And then you're not even in Virginia to issue these type of loans. You're doing consumer lending. I mean, it's just a plethora. And all I said was, hey, give me some grace and let's restructure this, and I give you 10 grand for the vehicle. 4 or 5 grand. You didn't put up 20 grand for that truck. You went through the down payment, which they told me you all received it. But ma'am, this is, so you all know the.
So Lamont?
Yes, ma'am.
I think you already spoke to, yes, you did, and a specialist has already spoken to you regarding this, and you've already let us know about this issue. And you even stated that you were going to go to DMV and have our lien removed.
But I'm trying to work with you. I don't want to just jump. I want to work.
This isn't something we don't alter the contracts. We don't make the contracts. They're done strictly through the dealership.
Ma'am, the thing about the contracts is the contracts, they're approved by you all. It is a credit acceptance retail installment agreement. You can't hide behind it. It's on. It is your form. It's your form.
We don't renegotiate loans. That's all submitted through it's only done through a dealership.
But ma'am, we don't work. I understand what you're saying.
The general public directly.
I understand what you're saying, but this I want you to understand with credit acceptance. The loan is not the loan that you're talking about. So you're talking about a loan, the deal. That's what would have been a loan. The dealer had with you all into the that you all extended. This is your loan. This is why
An issue. Yeah, this is not an issue that we can assist you with. I'm sorry.
Well,
I believe this has already been discussed with you back on the 10th.
Well, here's the thing. I'm calling the number back that just called me.
I know. And I don't know why, but I don't show that we reached out to you.
Yeah, you just called me. The phone rung 4 times. I couldn't get to it. That's why I'm calling this number back.
Okay. Well, and I'm sorry that I don't show that that our department reached out to you.
All right. Well, I don't know if this is your department, but all I'm going to just say this. All it says is credit acceptance 800-780-7022, and the call was placed at 3:41 p.m.
Okay. Well, I am sorry. There is no one from this department that reached out to you. I'm not showing any notes other than the ones that were noted on the 10th.
Well, I'm not saying this department reached out for me. I'm just saying this is the number that showed up on my caller ID 5 minutes ago.
Right. Okay.
So I don't know who called, and maybe it wasn't a ghost. Somebody from credit acceptance just tried to call me. Maybe it's the legal department that tried to call me, ma'am. You make way for it. Could have been that instead of you all.
Nope. I don't show that there's anything illegal here.
Ma'am, we're talking about a missed call. We're not talking about a completed phone call. We're talking about a missed call.
Right, I understand. It could have been just our automated dialer.
Oh yeah, y'all can. As long as all these violations that I have against you all, you actually think that I'm about to just throw my money away to you all? No, absolutely not. You're in violation all over the board, man. I can't in good faith. I can't in good faith because y'all not operating in good faith with me. This is why you're being sued by the Consumer Financial Protection Bureau in the Supreme Court right now. This is why your deceptive practices. You are stealing money day by day. Are convicting you. You can't even get a. Really, they're the ones that are telling on your whole company. Your own are pretty much spilling the bean how you really operate. And then when I speak to the customer service agent, y'all have no clue what I'm talking about. Y'all have no idea what's going on. All you're there to do is to collect pay. Oh yeah, while we're on the phone, ma'am, I would like to withdraw my consent to any electronic signatures, any electronic conveyance, whatever's on that credit application. I'm allowed to withdraw my consent. I do not consent from you trying to collect from me. I withdraw all consent. And that's on the credit application. I'm allowed to withdraw my consent. I do not want you collecting any sums of money under me because you're not entitled to the payment. Whoever you tell them to contact me, whoever that to contact me directly for payment. I don't want credit acceptance servicing my contract. So we're going to stop that. And yes, I will be having the lien removed. You bring your evidence with your attorneys. I'll bring my evidence and we'll see who prevails.
All right, sir.
Thank you. All right.
According to your conversation with the attorney, what we go over in group is right in line with the legal standards and the professionalism on how it has to look and what you need to know when you attack these people.
The words that he used was, "You're going about it standard operating procedures."
Don't miss out on this opportunity to litigate like a seasoned professional. Join the Supreme Elite Team University.
Thomas in the lobby. Folded thicker than a skyline. Credit acceptance on a resume with stories in the fine lines.
That aged like fine wine. As I tell you that aged like fine wine. That aged like fine wine, didn't it? That aged like fine wine. Good God. And you know what? With regard to that is, I try to warn him. I literally told her on the phone in the unredacted version. I literally told her everything that I was coming with. I literally told her. I didn't lie. I said, yo, I'm coming with this. I'm coming with this. I'm coming with this. I'm coming with this. And I'm not even hiding it. I'm not even hiding how I'm coming. Y'all gonna have fair warning how I'm coming. So when I filed the lawsuit, you know, before I filed the lawsuit, I didn't even, like I said, I didn't. I sent them everything. I sent them the first 29 pages. I sent them the first 29 pages of the lawsuit. Now I sent the whole what I was about to file, and then I sent them 29 pages of the what was it? 29 pages of the discovery. So they had many months to dissect it. I say, I'm not hiding. This is how I'm coming. This is how I'm coming at you.
The Supreme Elite Team University. Secure your seat in this revolutionary class now.
I wasn't playing. Wasn't playing at all.
Yo, Thomas in the lobby, folders thicker than the skyline. Credit acceptance on a resume, war stories in a fine line. Supreme Elite, circle around the table, every seat a throne. Consumer finance.
Wasn't playing at all. I sent them everything I had on them. It got so serious, and I tried to get them to settle even before. I said, yo, y'all need to settle, man. Come on, man. Y'all know if you don't settle, your investors going to be on your tops. Your investors going to be on your tops. Just settle. When your lawyer get in the picture, just settle. You're not going to win this one. I got you dead to I cut off all your, hey, listen, I've been researching y'all for 16 months straight. And then I sent them the final kill shot, the final, before, you know, remember with World War II, they dropped the bombs over here, Hiroshima and Nagasaki, right? And that's what ended it. So the final blow, because they were still silent, I said, I know they're not going to talk now because it's a legal issue, but let me leverage my way into a settlement. So when the lawyer get on, that'll be the only thing we talk about. I sent them their whole internal model. So you know that screen, that when you go to a dealership, when they behind the computer, when they communicating with them, I sent them that. What the dealership sees, what we never see. The only time you see is when they turn the contract around, you signing it. See, I sent them that. So I say, oh yeah, by the way, here's your internal model, by the way. Hey, I'm not filing it with the lawsuit because many consumer mindset people would have filed it. Like they're trying to, I'm gonna get y'all. I said, nah, here, I'm gonna send this directly to y'all. Ain't even going on the record. I just want to let you know. You can't even come to court and deny what I'm saying. Got your whole model. It falls under the rules of evidence, so I'll be able to use it to support my legal cause of action. Go ahead and settle. Go ahead and settle. Just go ahead and do it now. That's it. It's over with. Go ahead and settle. So I sent you your internal model. There you go. That's all it is. That's all she wrote. That's all she wrote. That is all she wrote.
The Supreme Elite Team University. Secure your seat in this revolutionary class now.
culture. We set order. We set order. Yo. Thomas in the lobby, folder thicker than the skyline. Credit acceptance on a resume, war stories in a fine line. Supreme elite, circle around the table, every seat a throne. Consumer finance in his bloodstream.
Using a tap?
Police say a potential customer will try